witness in this panel is Dr. Stephen Halbrook. Dr. Stephen Halbrook has practiced law for over 30 years, has authored or edited 7 books and numerous articles on the Second Amendment. Most recently, he drafted an amicus brief for the Supreme Court case, District of Columbia versus Heller, which was signed by Vice President Cheney, 55 senators, and 250 members of the House of Representatives. He's a graduate of the Georgetown University Law Center. Mr. Halbrook, I look forward to your testimony.
Thank you, Chairman Kaufman, Ranking Member Sessions, Senator Whitehouse. We've learned that Judge Sotomayor ended the great baseball strike, and we've learned that she was, as she is, a fan of the New York Yankees. However, in her decision in Maloney versus Cuomo, had the state of New York decided to ban baseball bats, it would be upheld under the rational basis test. Al Capone proved that you could bash out the brains of 2 colleagues with a baseball bat. Instead of banning one big piece of wood called a baseball bat, New York State banned 2 little pieces of wood connected by cord called an nunchaku. And that's what the court upheld in the Maloney case. But for our purposes, the issue is the decision in Maloney that the Second Amendment does not apply against the states through the 14th Amendment. The court relied, the only Supreme Court case relied on by Maloney was Presser versus Illinois, which simply held that the First and Second Amendments do not apply directly to state action. It was never raised whether the 14th Amendment incorporated the Second Amendment through the Due Process Clause. Presser relied on Cruikshank. Cruikshank relied on pre-14th Amendment cases deciding that the Bill of Rights did not apply directly against the states. But we find out in Heller, the Heller decision, footnote 23, that Cruikshank is not, does not apply because it did not engage in the kind of modern 14th Amendment analysis that's required by the Supreme Court's cases decided primarily in the 20th century, that Bill of Rights guarantees, especially substantive guarantees, apply to the states through the Due Process Clause of the 14th Amendment. Despite that admonition in the Heller case decided a year ago, the panel in the Maloney case did not say anything about the modern incorporation analysis. Now, Judge Sotomayor did say yesterday that under Supreme Court precedent, the Second Amendment does not apply against the states through the 14th Amendment. That's an inaccurate statement. The Supreme Court has never decided that issue. Now, there are pending before the Supreme Court 2 cert petitions on that issue. NRA versus Chicago, which arose out of the 7th Circuit, upholding the Chicago handgun ban, held that incorporation had to be decided by the Supreme Court. That court was not able to do it. And Mr. Maloney has filed his own cert petition. And in fact, he's asked that his case, if cert is granted in NRA versus Chicago, he's asked that his case be consolidated with the NRA case. Now, in her questionnaire in response to this committee's questions, Judge Sotomayor stated that conflict of interest would arise from any appeal arising from a decision issued by a panel of the 2nd Circuit that included me as a member. And she stated that she would recuse herself in that case. She has decided the issue now pending before the Supreme Court, and therefore we would expect and we would hope that she would recuse herself if she is in fact confirmed. Now, a case that, another per curiam case that she participated in deciding, Sanchez-Villar, has disturbing concerns involving both Second and Fourth Amendment rights. That case held that the mere possession of a firearm gave rise to probable cause to search, seize, and arrest the person in possession thereof. Apparently under New York law, it's a crime to possess a firearm, and it's only an affirmative defense that you have a license for it. In that case, the court stated that the right to possess a gun is clearly not a fundamental right. That was totally unnecessary to the decision. It upheld a conviction of an illegal alien for possession of a firearm. And the correct decision would be to say that illegal aliens don't have Second Amendment rights. And in fact, the court disregarded a Supreme Court decision, Verdugo-Urquitas, decided in 1990, which explicitly stated that the people, that term the people in the First, Second, and Fourth Amendments refers to the members of our national community, and not to aliens and not to illegal aliens. The third case I want to mention briefly, United States versus Cabrera, an en banc decision by the Second Circuit upholding a Gun Control Act prosecution and the sentencing under it. Judge Sotomayor wrote a dissenting opinion that I think is commendable. She made a statement that arbitrary and subjective considerations, such as a judge's feelings about a particular type of crime, should not form the basis of a sentence. And she explained in great detail the reason for that. And that's exactly the way the law should be interpreted, and constitutional rights should be interpreted as well. I think she made the correct decision in that case. And the question now is whether she will also take Second Amendment rights seriously, and that's the big unanswered question. Thank you.
In reading Miranda warnings, Mr. Halbrook, you wrote the brief on behalf of 55 senators in favor of in the Heller case, and your view, I guess, was accepted. And is it true that the decision, the Maloney decision, that Judge Sotomayor was a member of the panel that ruled on it, and you've expressed concerns about it, isn't it true that that case will need to be reversed, or the Second Amendment does not apply to the states in any city in the country, and state government could completely deny people the right to keep and bear arms?
Senator Sessions,
if that law became, yeah, go ahead.
The basic issue is, first of all, the meaning of the Second Amendment. In Heller, the court said it protects an individual right to keep and bear arms, including possession of a handgun in your home. And Judge Sotomayor's answers to questions about that decision, by the way, this week have been very non-committal as to whether she agrees with the decision. She does recognize it as precedent, of course. And then the next step, though, is the next issue is whether the Second Amendment applies to the states through the 14th Amendment's due process clause, like virtually every other Bill of Rights freedom: assembly, petition, free speech, press, unreasonable search and seizure, right to counsel, the whole works. And it's only logical, once it's conceded, it's held that it's an individual right, that it would be considered an explicitly guaranteed right in the Constitution. Being explicitly guaranteed normally means it's a fundamental right, and the test of instead of rational relation, the compelling state interest test would apply, like other fundamental rights. And so that's the issue that's before the Supreme Court right now.
Regardless of whether or not the precedent justified the decision in Maloney, and I think we can argue about that. But the point is, that decision would eviscerate effectively the protection, the constitutional protection to keep and bear arms, if it became the Supreme Court opinion. The Supreme Court affirmed that approach. It's going to need to reverse that approach, or the Second Amendment is severely weakened, really eviscerated.
Well, most of the firearm
laws... Is that right,
laws,
fundamentally?
that's correct. There's 20,000 firearm laws on the books. Most of them are at the state and local level, not federal law. Federal Gun Control Act has expanded greatly in the past years, but most firearms possession issues involve state and local law. And the ruling in the Seventh Circuit case in NRA versus Chicago, the ruling in Maloney, is that the Second Amendment has no application to states and localities, so you could ban firearms, you could ban anything you wanted to ban, anything that would be an arm. The Second Amendment just doesn't apply. And it would be a curious doctrine that here you have a fundamental right protected in the Bill of Rights to say that it only applies to the federal government. The 14th Amendment's framers desired and intended that the Bill of Rights guarantees apply to the states through the 14th Amendment. And one of the big issues of protection was the right of freed slaves to keep and bear arms, because they were violated by the black codes that were enacted by the southern states after the Civil War. And to get rid of that kind of discrimination, to allow freedmen to keep and bear arms, to have free speech, and to have all the other rights that are set forth in the Bill of Rights, that was the intent of the 14th Amendment. And that's the issue before the Supreme Court now, and that's the issue that Maloney decided adversely.
Thank you, Mr. Chairman. Very kind.